and there are written statements provided by the parties. So I would like to have the opportunity to present those statements and any property management I can subpoena to be there for jury trial.
Do you have witnesses here?
I do have witnesses here.
We had witnesses subpoenaed here twice for no reason.
Your Honor, I apologize. I didn't mean, this is a case that we had set for a final pretrial and jury trial within a month of the first pretrial conference. I apologize for not having this information beforehand, but I do believe that it would be beneficial to have that at defense. And I believe there was no objection from the prosecutor.
That's correct, Your Honor. We don't object.
Okay. How are you, Ms. Allen? I'm doing okay. I do have a problem with not making sure we are moving in the best interest of judicial economy when it comes to bringing in witnesses. Because if that was the case, someone should have been notified immediately so that we didn't have witnesses hauled in here on a jury trial day. I'm going to grant the adjournment, obviously, because I believe there's something that's in the best interest of your client. This case, and so I'll give you a date. Well, we're not doing a jury trial on election day. Worst day.
Thank you, Your Honor.
November 15th. November 15th at 8 a.m. in person. Jury trial. I don't know if you need, or we're going to be needing motions of any kind, but.
I don't believe there will be any motions. No.
Okay, sounds good. Do you have any questions today, ma'am? Okay, you've already advised your witnesses.
Yes, Your Honor.
Okay, we're all set with that file. What's going on with Kiana Ray?
Ms. Ray, I don't. No, you're not. You're right. Damn it. Okay, so
That's right. Don't take ownership for that.
I had yeah, sorry.
Haven't seen her?
You're with her. That's right. That's how I recognize you.
You haven't
I
seen her?
recognize someone. No, I don't. Her phone's disconnected, Your Honor. I wasn't able to get hold of her this week. So.
Okay, I think he gave me a picture. Okay, who's going to trial then? Morel?
That'd be correct, Your Honor.
Yes, Your Honor. Let me bring that.
Thank you.
Oh, you got
On the record in the matter of the people of the state of Michigan versus Christian Alex Morel, file number 22-02108, council appearance.
Brian Ring on behalf of the people.
Morning, Your Honor. Harry Meehouse on behalf of Christian Morel. Mr. Morel, state your name, please. Christian Morel.
Okay, today's the date that's set for jury trial. Are we prepared to proceed?
You are prepared to see, Your Honor.
Your Honor, we're prepared, although I will raise to your attention an email that I sent your staff last week. Possible conflict depending on how long the jury would stay out. They have to be in court here on for a federal matter tomorrow at 2:30. I wasn't aware that the jury is called at 10 or 10:30.
They're called in at 9.
At 9.
They don't want to get here until 10. Yeah.
It's my one concern.
How many witnesses? It's up to you all. How long-winded are you? How many witnesses you gonna call? I've never had a 2-day jury trial yet. Some other judges have. I just haven't.
I don't anticipate 1, maybe 2.
I only anticipate 1 or 2 as well. I plan.
No reason why we won't be able to finish it today.
I have a band. My daughter's a band concert tonight. I've got to get to too.
He's not.
Maybe.
He knows not to make mom.
Okay, so we'll call in the jury. Any other matters while we're on the record now?
Nothing on behalf of people, Your Honor.
Nothing.
Okay, sounds good. We'll adjourn until the jury gets here. Thank you.
Can we set up here or?
Uh,
do you
not
have other
now.
matters?
Yeah, we have some other matters we gotta clear. Okay.
Right.
Who's on, Mr. Margosian?
Yes, Your Honor.
That was.
Ms. Donnelly? Or Mr. Lee?
I will. All right,
Just need to speak to Mr. Margosian.
just to let him know it was dismissed.
It was.
It was.
Can I sign it? Okay. Mr. Margosian, your matter was dismissed, okay?
All right, thank you, Your Honor.
Thank you.
Thanks, everyone.
It was witnesses. Is that what it was?
Yeah.
You guys.
Okay. He's still hanging out, I think. Yeah. Did you have a question, Mr. Margosian?
No, not at all. Thank you.
Okay, well, then you're free to go. Your case was dismissed without prejudice.
Thank you.
No problem. And then we're not anything until. 9:15, I'm gonna go to these jury instructions. I'm not gonna be doing anything after 11 o'clock. When the jury gets here, I'm going. So I'm not doing a PV or.
Okay, all right. I'm just gonna let, I guess we're down some attorneys, so they're. I need to let them know that we're not gonna have. My court will be pre-trial.
Why?
Thanks. I'm committed myself. Did she discuss whether she was gonna run the arraignments at 11 or whether she was just gonna adjourn to 2?
She said she's done it, but she's definitely not doing anything at 1:30.
I know, but she would want to probably start the jury selection. at 11.
Actually, yeah, no, we'll have to reset that TV right.
That's what I figured. Okay, all right.
There's only two. I mean, you should, but
Yeah, so, yeah, just. Oh, they have to do it in person.
But they expect me to participate. Starts at 9. Should I try to come back to the office or is there something?
9 a.m. right now. Oh, yeah. Yeah, go to, I mean,
Is there someplace?
let's go. Let's go. I mean, it's better to just go back to the office. The room is kind of limited here. We only have these rooms and.
Did you mean to print the far away?
No, I don't even know which hour whatever.
There's a lot. The Allen did.
It's the files for afternoon and 11. Are they still up there?
What do you want?
That probation file.
Afternoon or the 11th?
All of them.
These are Karen's label and-
Yeah. 11th. That seat person that would consider your face on. Oh.
Well, hopefully she didn't go for it. Maybe she's going to the after.
Yeah, that's what I'm hoping.
It's on the first floor, I guess.
But I mean, the Dale and Bill don't remember seeing her. I'll give it a couple minutes to make sure in the bathroom and I'll give her a call. Did she hear you saying that the witnesses could go? No, she wasn't there. Okay. She asked if she could run the kids to school and I was like, nope. I was like, nope, sorry. Maybe she got scared, right? Are you on most of these matters this afternoon?
I'm on all the matters today, yeah. They're still
Okay.
slowly moving.
Good morning. Who just logged in with an iPhone?
Tamia Williams.
Thank you.
Good morning. Who's on the cellular 5G?
Yes, this is Wando McCollum.
Mr. McCullum, are you in an area where you can stabilize your device?
Yes, that's what I'm trying to do right now.
Whoever issued this did.
Mr. McCullum, you're supposed to be here in person, sir.
Nine-one-one call and CAD and all that. And she requested. No.
Mr. McCullum, are you there?
Yes, can you hear me?
Yes, you're supposed to be here in person.
Had to go to work. I gotta get ready to go to work. All right. Can you hear me?
Yep, you still need to be here in person.
All right. Can you give? If I make it there by before 10, would that be okay?
You need to get here as soon as possible, sir.
Yes, sir.
Wasn't a blade or anything involved, right?
No. All right, Ms. Kurgis, we're waiting for the judge. We'll get, this dismissed on the record, okay?
Okay.
Thank you.
Morning, Mr. Cornish.
Hey, good morning.
Who do you have with you, sir?
Ms. Hartman?
Okay.
Is it show cause phone?
McCullum showed up on Zoom, but I told him he to be here in person.
Tamia Williams did dial in, but somewhere she got.
The PA said they were supposed to be in person.
Yeah, he's still, Your Honor, he's still in warrant status. I believe the court set it for
Got
that
it.
because he failed to appear. In the case.
Got it. Well, if he comes on trial, he's just gonna have to be in custody until we're ready to go. What else to do? Okay, and then Kyrgyz.
Fergus, Your Honor, was the dog license. We should be able to dismiss it on a ticket, so motion should be fine.
Moving to dismiss Kyrgyz.
Sorry, yeah.
Are you moving to dismiss Kyrgyz?
Yes, sir.
Okay, Ms. Kyrgyz, your matter is dismissed, okay?
Thank you so much. You guys have a wonderful day.
Same to you. They were putting Christmas lights out there today, guys. Just so you guys are aware. They're putting lights on the trees outside today. I was like, listen, they're not even waiting for the Halloween no more.
I didn't want to wait for it to get too cold, you know?
That's what I was thinking. Could snow any day, you know? Okay, Quandale. Oh, Quandale. This needs up here person. That makes sense. Okay. No, Tamia Williams, correct. Benchmark for Tamia Williams. Who did Mr. Cornish have again?
Pardon?
Okay, we're on the record in the matter of the people of the state of Michigan versus Yvonne Hartman, file number 20-01564, council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. May it please the court, Steve Cornish on behalf of Ms. Hartman, who's in my office sitting here next to me.
Okay, and today's the date that was set for a pretrial and one count of assault and battery. How are we proceeding on this?
Thank you, Your Honor. We'd just be asking the court to set this matter on for a final pretrial.
Trial November 8th at 8 a.m.
November 8th at 8 a.m. for final pretrial.
Trial
Very good, Your Honor.
November 22nd at 8 a.m.
No, jury trial will be November 22nd at 8 a.m. Does that work for you?
Yes, Your Honor.
Okay. Any additional matters for the record at this time?
Nothing from the defense, Your Honor. Nothing from the
You're all
defense.
set. Okay, you're all set. Thank you.
Thank you, Your Honor.
No problem. What happened to Flores and Jinsky? Are they in custody?
Yes, Your Honor, it's fine, yeah.
Vincent Flores, right?
Mhm.
You bring Flores up already? Were they logging them in? Okay, and you said Jinsky didn't want to come? Oh, okay, well, I'm assuming she's gonna have to use today too. So I think I just reset this because I thought we were gonna get another order. I can address this without them. If our attorney wishes to waive their appearance. We're on the record in the matter of the people of the state of Michigan versus Joyce Jinsky, file number 21-03487 SM. Council appearance.
Randall Berman on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Joyce Jensky, who is in Ingham County Jail custody, refuses to leave her cell, so I'd be waiving her appearance.
Thank you. I reset this matter because we were here last week, and it believe that the people in the defense were stipulating to a report that was received by Judge Hillman's court. I realized we're not going to get one because she refused the first time unless I issued a new order. They were not going to reset hers. So we can go ahead and move forward with adopting that record unless there's an objection.
Not on behalf of the people, Your Honor. I've had an opportunity to review the report that was conducted or
authored for the Judge Hillman case. It appears as though the defendants needed services at the Center for Forensic Psychiatry, and that our notes from the file indicate that she was remanded for transport, and the hope is that she will become competent. And I would support court issuing an order that mirrors that.
Your Honor, in the defense, we have no objections to the competency report. We would also stipulate to it.
Okay, that report will be adopted and incorporated into the file, and I'll enter an order reflecting the same that she used to undergo treatment at the Center for Forensic Psychiatry, and the hopes to regain competency within the statutory time frame. And we'll set this out for review date to see, to make sure we follow up, since we're not the ones receiving the original order on this. Suggest this on September 15th. Well, they sent that to Judge Hillman on September 15th. Can you give me, set it for an internal review in 60 days so we can follow up? The review will be January 60 days takes us into 2023. Is that what we're doing now?
Oh, gosh.
Whew. That is a little scary. Okay, January 3rd, 2023, huh? First order of business next year. We're following up on this. Any additional matters for the record?
None of the have to speak, Your Honor. Thank you.
Not for defense, thank you.
Okay, thank you. Mr. Pugh is in the waiting room. Who's on the Samsung SM? Get super hot. It's on the Samsung SM. Hi, sir. What's your name?
Oh, Raul Flores. I'm sorry.
Okay, Mr. Flores. Do you have an attorney, sir?
I do not.
Okay. Someone want to log in and meet with them?
Yep.
Okay, give me just a moment. We'll have the prosecutor log in to discuss this matter with you.
Thank you.
And then no problem. I see Deontay Pugh.
Yes, ma'am. Can you hear me?
I can hear you.
Okay.
I don't see Deontay on my docket. It's probably supposed to be before the camera.
Yeah.
Mr. Pugh, I think you're supposed to be before Judge Buchanan today, not here.
They told me it was supposed
Actually, November 14th? I'm sorry? Both of them on November 14th? Our records show you're supposed to be before Judge Buchanan on November 14th. Did you get a notice to appear today?
Yeah, I had a paper. They told me I was supposed to come today at 9:30.
Well, you don't have a case before me at all. I'm Judge Simmons.
Okay.
Give me just a moment.
Okay.
Me?
He's supposed to be there with them yesterday.
You were supposed to be with Buchanan yesterday at 9:30 though. So you might want to log in to Judge Buchanan's and get that taken care of, because they probably either issued a bench warrant or they're holding the case for 48 hours before they issue a bench warrant.
No, I talked to her yesterday about my larceny case, but they said I was supposed to see you about my domestic violence case.
Who's they?
I got the papers, but they in my room.
No, who did you speak to? You said they said you're supposed to see me. I want to know who they is so I can talk to them.
I don't know the officer name, but it was the person at the desk before I left.
Oh, yeah, the person at the desk can't tell you who you're supposed to speak to. So you should have got a notice to appear, and they would have had which judge? His domestic violence is before who?
Buchanan.
Your domestic violence is before Judge Buchanan. It's not before me.
Well, oh, okay, that's crazy, because on the paper, I got a paper saying that it was supposed to be for you, though.
I'm not disputing that didn't happen, because it could have happened.
Right.
What I'm saying is that would have been an error if they sent you a paperwork that said it was before me. Your domestic violence is before Judge Buchanan. And then it looks like you have another case before Judge Buchanan. Did you appear before Buchanan yesterday?
Yes.
He's not in bench warrant status. Oh, okay, yep. So it looks like you did have your pretrial. Yeah, you don't have anything before me that I see. You're definitely not on my docket for today.
Was he subpoenaed for?
Okay.
Oh, were you subpoenaed to be a witness in something?
No, ma'am.
What's your attorney's name?
It's all on a piece of paper, but I left it all in my room. If I could go get it, if that's okay.
Yeah, you can. That's fine.
Okay.
Showing up.
Did you put them in a breakout room?
Carol Simon.
That's not your attorney. She's the prosecutor. You admitted Mr. Bierman, you put him in the private room. That's the prosecutor. She's not your attorney. Have you spoken to your attorney? I would imagine if you had court yesterday, you spoke to an attorney.
Oh, okay, then yeah. It was I forgot his name, but I think it was David. I think his name started with David.
Say what?
Raleigh. He has Raleigh.
Okay, yep. Raleigh is his first name or last name?
Last name. Raleigh.
His last name is Raleigh. Does that ring a bell? What's his first name?
Jacob.
Jacob Raleigh? Does that sound?
Okay, I'm sorry. Yes, ma'am. That was it.
Yep. You should probably talk to him. And
Okay.
then, do you have his contact information?
I don't, but he sent me an email yesterday. I don't know if that would come with it or not.
Yep, if not, you can just respond to that email and let him know you logged in, you're not sure where you're supposed to be, but confirm all your court dates with Mr. Raleigh, okay?
Okay.
You're all set for today, though. Thank you.
Okay, thank you.
No problem. Okay. Raul Flores in the meeting room. Vincent Flores.
Which one's first? Vincent Flores. I do want to talk to him in a break.
Okay, Mr. Flores, hold tight. Your attorney's gonna come talk to you, okay?
Okay.
Flores and Flores. We're on the record in the matter of the people of the state of Michigan versus Raul Flores Jr., file number 22-02292. Council appearance.
Thank you, Your Honor. Randall Berman on behalf of the people.
And Mr. Raul Flores is appearing today without an attorney. He met with you privately. How are we going to proceed on this?
Your Honor, Mr. Flores has provided me with verification and proof of the dog being licensed. At this time, the people move to dismiss the ticket. Thank you.
Okay, the case will be dismissed. You're all set, Mr. Raul Flores Jr.
Thank you.
Thank you.
Have a good day.
Same to you. We're on the record in the matter of the people of the state of Michigan versus Vincent Flores.
Randall Berman on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Vincent Flores, who is appearing separately from the Union County Jail.
Thank you. I have two files here, file 22-00828 and 22-02741, both assault and battery. Are we proceeding to final pre-trial on these?
Yes, Your Honor, I'm requesting a final pre-trial on your trial.
Final trial will be November 8th at 8. And jury trial will be
okay. Tuesday. I could be wrong. I don't think we're calling them juries. It's 27th. Like, isn't that the week of Thanksgiving? I don't think we're calling it juries. I think they're not gonna allow us.
so November 20th.
The same week. You said November what?
29th is the
Oh,
next week.
29th. Yeah, we can do the 29th, I'm sure. They're not gonna do the 22nd because of Thanksgiving holiday. Yeah. Okay, so final pre-trial is gonna be November 8th at 8 o'clock in the morning. Jury trial November 29th at 8 o'clock in the morning. Do you have any questions today, Mr. Flores?
No, ma'am.
Any additional matters for the record, counsel?
Bond on behalf of the people, Your Honor.
Your Honor, yes, I'd be making a bond request. All right, thank you, Your Honor. On behalf of Mr. Flores, we'd be requesting either a personal recognizance bond or a 10% or some cash bond. Mr. Flores right now is being remanded. I think it's because of a history of failing to appear, but he reports to me that he has been in custody for the last 11 days or 15 days. He does have another pending felony now with a bond on that as well. So he reports that if released, he would live with his girlfriend, Maria Love, at the address on Capitol. He's known her. He's lived there for about 3 months. He even visited. He's spoken to her. Yeah, she just visited yesterday. He also reports that the number he provided, I believe it ends in 9986. That's his mother, Meredith Diaz. He also talks to her regularly since he's been in jail. So he believes that he has. He can be found. He can be and he can be contacted. He says he will appear for his court dates. But like I said, if a personal recognizance is not appropriate, Your Honor, I would just at least be asking for some sort of cash bond because right now he is just remanded. Thank you.
He's definitely not getting a personal recognizance because he's missed over 3 times on this file. Nonetheless, we have an address on Jessup. That's the address he's gonna work.
You can put down 831 North Capitol Avenue, Your Honor. That's his address. That's where Miss Love is. Where he supports that she lives.
We have a phone number ending in 5494.
Then he provides a phone number 624-9986. That's his mother, Meredith Diaz.
Oh, so I don't particularly think that it's the court's job to try to find him, and when he doesn't appear, it's his responsibility to keep up with his court dates. And he's multiple times used the excuse that He couldn't find his paperwork. And that he should be more responsible with an exact quote, I think, at least on one of his arraignments or benchmark status, but nonetheless, I'll amend the bond, I think in file number 02741, he does have a bond.
He has a bond in that new case and it has converted to a personal license, so it's not holding him in jail.
Okay, this one will be set at 1010%. Need to make sure you appear to court for all your next court dates, and also the other no contact order and other bond conditions will continue. Okay, Mr. Flores,
Yes, ma'am.
you have any questions?
No, thank you. I appreciate it.
You're all set. No problem, you're all set.
Thank you.
No problem. Let's see here. Baldwin. There's a lot of people in the. Okay, Mr. Zini.
Your Honor, how are you this morning?
I'm well. How are you?
I'm glad to be here. I shall rise and say what's up.
Nice
to see
tie.
you. You doing good?
I'm hanging in there.
Good.
Okay, and so you're here with Mr. Terry?
Yep, he's in the hallway.
Okay. Are you receiving final pretrial or?
It's just his first pre-trial. I got to chat with the Honorable Randall Burke.
Probably. Yeah. He's probably gonna send Mr. Ring.
What's that?
He's gonna send Mr. Ring to talk to. Don't, you seem nervous. Mr. Ring.
The beard. Plus, I really enjoy Mr. Berman.
Yeah, he's a little busy. We gotta get ready for a jury trial.
He was tough to deal with. Be careful with.
Okay, who we have here?
We have Mr. Quandale McCollum, Your Honor.
Oh, Quandale McCollum. How are you, sir?
I'm doing good. How you doing, John?
Oh, I'm doing pretty good. We're on the record in the matter of the people of the state of Michigan versus Quandale. McCollum. File number 22-02409.
Randall Berman on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Quandale McCollum, who is present and standing to my right.
Yeah, I don't know how Ms. Glasgow's information got in here. That's right. Nonetheless, Mr. McCollum, we had to set you and bring you in for a PA 53 violation. And you know, I'm gonna be very frank. I kept getting these alerts that you were within the exclusion zones, and I was giving you benefit of doubt. Like, I'm gonna give him grace. 1 minute, he's gonna be okay. And then you kept doing it. Then the time frames started getting longer. So that's why we had to bring you in, because we had all of these allegations that you keep entering into the exclusion zones. And so I have an allegation that on or about September 27th, that you entered the exclusion zone at 2:34 p.m. and you exited by 2:35. I don't know if all of these have been printed and placed in here, and that's part of the problem. Or maybe they're not on the right side. That's what the problem is. They're not on the right side. I have another violation alleging that on October 14th, that you entered the exclusion zone at 8:19 p.m. and exited 8:21 p.m. A lot can happen in 2 minutes. There's an allegation that you entered the exclusion zone again on the 14th, 3:28 p.m. and then you exited 3:29, but then you went back into the exclusion zone 3:52 p.m., exited at 3:54 p.m. There's another violation alleging that you entered the exclusion zone also on the 14th at 1:17 p.m., exited at 1:18 p.m. I'm not finished yet. Another violation alleging that on the 13th of October, you entered at 1:29 a.m., exited at 1:30 a.m. Here's another one that alleges, I think that this is the same one I read before, which is on the other side of the file. Multiple violations of your GPS tether exclusion zone is what we have here. You have the right to have a contested hearing on the alleged violations. You have the right to be represented by counsel at that contested hearing. And if you're found to be in violation, sir, that would be a contempt order, a contempt violation for the court's order, and you're facing possible penalty of 93 days in jail and or $7,500 for violation. Do you understand that?
Yes, sir.
I just want to plead.
Your Honor, at this time, he would be pleading not guilty. I have not received any of the information for these allegations, so at this time, I would not be advising him to.
Okay, we're gonna enter a plea of not guilty at this time. I'm going to, at this point, remind you, do you know what the exclusion zone is, sir?
Learning. I know that MLK, Jolly, I cannot go down.
Well, apparently you're getting really close a lot. So I don't know if this is the route you're taking to get to family, friends, home, or work. But you probably want to talk to your attorney off the record about what the issue is as to why you keep triggering these alerts. Because again, like I said, I tried to ignore them and then they just kept coming. So I had to bring you in at this point. I can't ignore like 10 violations on the exclusion zone, okay? So Ms. Donnelly will advise you will enter a not guilty plea. You were also on bench warrant status, because you were supposed to be here on the 4th for pretrial. What happened?
Your Honor, what happened was that the information that my lawyer sent me, I didn't get.
You're gonna blame it on
No,
her?
we don't
Oh.
talk about it.
Okay.
If I did know, I would have been.
Okay, because you were actually given your court date for your first pretrial. Looks like that was reset. It's October 4th. I don't really have a note in here as to why it was reset, but here today, we'll get you a new pretrial date and we'll set the PA-53 for the same date, okay? November 8th. November 8th at 10 a.m. So I'm telling you the time and right now and the date. So you're not able to use the excuse that you didn't get the information that your attorney sent you, okay? Because I'm telling you right now, and we're gonna give you a copy of the paperwork.
Yes.
You have any questions?
No, Your Honor.
I'm sorry? Well, if we're gonna run PA-53 here, and he has to come in person. We're not gonna run it, we can do it via Zoom. Your attorney. If I don't get any more violations between now and then, I'm happy to withdraw those. November 8th at 10 a.m. No questions, no additional matters.
Not on behalf of the people, Your Honor, thank you.
No, Your Honor, not for defense. Thank you.
You're all set. We'll get you a copy of your notice, sir.
Okay.
I see someone in the Ingham County Jail. Who's that? Ma'am, what's your name?
Ramona Hunter.
See if our attorney needs to speak. Did you all have a chat, Mr. Zany?
Oh, yeah, we're ready to proceed, Your Honor.
Okay. I'm assuming there's no offer, correct?
Not at the time, Your Honor, you're correct.
Told you he's a tough guy with that beard, Judge.
Only that's just been. Typical.
I get, yeah, we're all on the same page.
Yeah.
Like,
I assume there's gonna be final pretrial. This is November 8th, work for you. November 8th at 8 a.m. in person at the court. If this proceeds to trial. Jury trial, November 29th. Is November 29th work? We'll do it November 29th, also at 8 a.m. Anything else we need to address today?
Nothing from people, Your Honor.
Nothing from the defense, Your Honor. Thank you for your time.
Thank you. Have a good one.
See ya. I guess. Your Honor, next up. Stand, please.
Thanks.
Okay, I have Ramona Hunter. Does somebody need to speak to her?
Yes, I do, Your Honor.
Okay, Ms. Hunter, your attorney's gonna log in. I have Mark Caldwell here for Stephanie Norris.
Yes, Your Honor. Good morning. I still need to speak with the prosecutor.
I'll do that, Judge.
Okay, I just see Mr. Bierman's in the waiting room. He's gonna log in and we'll
Okay.
place you in a private meeting room.
All right, thank you.
No problem. I see Reginald Baldwin. Oh, he didn't connect. And then he's not. He left. No, what happened to him? There he goes. Reginald Baldwin.
Yeah.
Okay, can you see, we'll see if your attorney needs to speak to you, okay?
All right.
So it sounds like, the public defender is gonna be.
Hello?
Mr. Baldwin, hang tight. We're gonna get you in the room with your attorney in just a moment, okay?
Oh, okay.
I'm afraid.
Okay. The prosecutor, the public defender's not here for Hunter. Okay, we ready on Norris? We're on the record in the matter of the people of the state of Michigan versus Stephanie Norris, file number 22-02588. Council appearance.
Thank you, Your Honor. Randall Berman on behalf of the people.
Attorney Mark Caldwell on behalf of Miss Norris, P 71729.
And today's the date that was set for a pre-trial. I do have a plea sheet. It says that people are offering for the defendant to plead guilty to an added count 2 of operating while impaired. It's a misdemeanor. Maximum penalty is 93 days and or $300 and or 300 hours of community service. There's a killable of no upfront jail, and it looks like there's restitution.
Cost reimbursement, yes, sir.
Oh. OWI cost recovery, and then Ingham County prosecutor. It's how much is that one?
120, did I not put that on there?
Oh, I don't think it is on the, oh, it is up there. Yep, 120 on that one, and the other one is 489.55. Mr. Caldwell, is that a complete and accurate? Oh, he froze. And then he's gone. Is Ms. Donnelly speaking to someone? Oh, okay, who's on the other Samsung then? Who's on the Samsung SM? Okay, Mr. Carwell's back. Okay, welcome back, Mr. Caldwell.
Sorry about that. They're doing some kind of internet service around here, and so now I'm on my phone.
Okay, no problem. I was just going over what the offer was, which is to plead guilty to an added count 2 of operating while impaired, and there is a killable of no upfront jail and stipulation to the OWI cost recovery owed to the MSU Police Department and Ingham County Prosecutor. Is that accurate?
Yes, Your Honor.
Okay, and Ms. Norris, you want to accept that offer today?
Yes, I do, Your Honor.
Can you raise your right hand?
Oh, yes.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, yes, I do, Your Honor.
Thank you. You can put your hand down.
Okay.
Okay, Ms. Norris, you have the right in this matter to proceed to a trial, and you have the right to have a jury trial. At the time of jury trial, you have the right to be presumed innocent until proven guilty. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any of the witnesses that the prosecution intends to call. You have the right to call your own witnesses or present evidence at trial you believe would further a defense of this charge. You have the right to have each element of the charge being brought against you proven beyond a reasonable doubt. And you would need to give up each of those rights today in order to accept this offer. Do you understand that?
Yes, Your Honor.
Okay, and you're willingly giving up those rights today?
Yes, Your Honor.
Has there been any promises made to you to get you to waive your rights and plead guilty?
No, Your Honor.
Okay, you currently on probation or parole?
No, she is not, Your Honor.
Okay, she's got to answer.
No, Your Honor, I'm not.
Okay, you understand that a guilty plea could result in a conviction that you may need to report to your current employer?
Yes, Your Honor.
You understand that a guilty plea could result in a conviction that may have an impact on any immigration status you may be seeking, such as entry into another country, in like
Yes, Your Honor.
Canada?
Oh, sorry.
Okay.
Yes, Your Honor.
Right. You understand that a guilty plea could result in you having to place a conviction on a future job application?
Yes, Your Honor.
Okay, and has there been any promises made to you if you waive your rights here today and plead guilty?
No, Your Honor.
And are you entering a guilty plea today because you believe you're guilty?
Yes, Your Honor.
You sure about that? I see your attorney's nodding, so I know he's indicating
Yes.
for you to say yes, but is
No,
that
no.
your answer?
Yes, it is.
Okay. You
Sorry,
believe-
I'm
you
not used to
believe-
this kind of thing.
No worries, I'm asking pretty basic questions. Do you believe you're guilty of the charge? That
Yes.
You're entering a guilty plea to?
Yes.
Okay. As to the added count 2 of operating while impaired, how do you plead, ma'am?
Guilty, Your Honor.
Okay, can I have a factual basis, Mr. Caldwell?
Yeah, I don't have a police report, but I'm trying to see. It's hard to do about a police report because I don't have on
August 13th.
On August 13th, were you driving in Ingham County, Michigan?
Mr. Caldwell, I'm not sure why you don't have a police report, but we'll have the prosecutor do it because I don't have a police report either.
Yeah, I did request one. I just haven't received one yet. So.
I'm sorry, you haven't received a police report?
No, I have not received it.
Okay, I'm not accepting a plea.
But
I don't know
Your
how
Honor,
you advise your client without reviewing a police report.
Your Honor, I don't need to see the police report. I've been in practice for 15 years. Her BAC is a 0.17. The offer is to an impaired. She would like to take that today. I am fully advising her.
I would not go on the record. I would never go on the record as indicating that I've advised my clients to accept the plea and I haven't even seen a police report.
Well, in this case, Your Honor, the deal's not going to get any better.
I'm not saying it's going to get any better and the deal will remain open, but you have due diligence as an attorney under your professional responsibility to make sure you review a police report. You don't even know if her rights were abridged. You have no clue what happened.
Well,
Because you haven't seen the police report. You've not gotten any discovery.
Is the prosecutor willing to leave this open, the offer open?
Of course.
Absolutely.
Okay. All right. Well, we'll if we can adjourn this to a second pretrial.
We'll reset it to November 8th at 10 o'clock.
All right. Thank you, Your Honor.
Thank you.
Yep.
You're all set, Ms. Norris.
Thank you, Your Honor.
Instead of raising your hand, you need to unmute.
Okay.
Okay, what's your name? What's your name?
Tracy Terry.
No, I don't see Tracy Terry. Do you have a case number, ma'am?
It is 225429.
This is 5429. It's probably a 0. No? Are you missing a number?
No, that's what's wrote on, it's 225429. That's what's wrote on my paper. Hold on, let me, I'm for, Michael Terry. Hold on. It is.
Oh, okay. That makes sense. This looks like she's a witness. Okay. You did not receive a notice to appear today, though, did you?
No, I was told by, the, domestic violence advocate, to participate or you guys would drop it.
Okay. It wasn't a final pre-trial today, then. Okay, today was just a pre-trial, so you did not need to appear for the pre-trial, but we did set it for a final pre-trial and you will need to appear for that, okay?
When is the final pretrial?
November 8th at 8 o'clock in the morning, and you have to come in person, okay?
Okay, and what do I do if he's had contact? Do I just contact the police department?
Yes, please.
Okay, thank you.
Give me just a moment. The prosecutor wants to speak with you, okay?
Okay.
We're gonna put you in a private meeting room with the prosecutor.
Okay, thank you.
Thank you. You should receive, a pop-up should have come up on your screen to join the breakout room. He did log out, I think.
I can't find me.
He logged out.
This is philosophical.
It does say that you were in room 3. I don't know why it says that.
It probably was.
Oh, no, he is on there.
Did something wrong. Okay.
I don't know why he's not on the main thing, you know.
I just. zooped back
Weird.
in.
Okay, sounds good. We ready on Ms. Hunter?
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Ramona LaShawn Hunter, file number is 22-01857. Council appearance.
Brian Ring on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Ramona Hunter, who is appearing separately from the Hale County Jail.
Okay, how are you, Ms. Hunter?
Say that again, please.
How are you?
Hi, how are you? I'm fine.
Okay, today was the date that was set for a pre-trial for one count of malicious destruction of a building. How are we proceeding on this?
Your Honor, at this time, I believe the offer will be pleaded as charged and there'll be a killabrew, but, and I do believe Ms. Hunter wants to accept it, but Ms. Hunter got arrested on Friday. She's been in custody on a bond violation on this case. She's gonna be arraigned on it this afternoon. So at this time, I don't want to, and there is a question of restitution. There is a dollar amount in the discovery, but there hasn't been a receipt provided, so we'll hopefully have that one more assuredly, but yeah, at this time, we want to just reset pretrial conference, probably for the date of the PA 53.
Is it PA 53 on this file?
I believe that's where, yeah, she got arrested, yeah, for using out drugs. I'm not exactly sure though.
I'm looking at it to this file if that's the case.
Let's see if there's.
She's just gonna be arraigned on the new case today, you mean though?
No, it's my understanding, Your Honor, there isn't a new case. It's just going to be a bond violation on one of her current cases. It's my understanding that this is the only current case that she has open with my office. So I'm not exactly sure what's happening.
October 31st, on what file, this one? No. It's another one? She's set for arraignment on. Oh, no, alcohol in public. Who did that?
I don't know.
For a probation violation, I mean, for a PFP violation on alcohol in public?
Excuse me.
Oh, she has a new charge for alcohol in public. That's what it is.
Okay.
So
I got
they
that.
probably have not sent it to me to have it set for PFP. It's probably what it
Well,
is.
ma'am, I got that alcohol in public the day that I was arrested for what I'm here for today. I actually got that the same night that I was arrested for what I'm in here for today.
Right, it
So
sounds like you weren't arraigned on it though.
No, I was not.
Okay, that's what you're gonna be arraigned on the 31st. But why is she
Yes.
on the 31st?
Yes,
I
that's
mean, why?
correct.
Just do it right now though. What, she's being held on something else?
Yeah, Mr. Goodrich had talked to her this morning and he informed me, yes, it's a bond violation that she's being held on.
I'm bonded out for
When was
this
she picked
charge,
up?
but I,
Friday.
You get an email about her? I'm trying to figure out how she held on a bond violation. Okay, 1 hour ago, we got an email. How about that? And not Monday. But it has nothing to do with us. She's in the England County Jail. She is scheduled for pre-trial. She is not in jail. She is on the arraignment list. Okay, what else? I'm trying to understand what she's held for. Who's holding her?
so I'm being held on a bond violation, but I called the police to get help at a gas station. And when the police showed up, they arrested me because I refused to PBT. And I allegedly told them that I had been using drugs, but I hadn't been using drugs, Your Honor.
Okay. Okay, I'm just trying to figure out who has the holds. I'm happy to arraign her on the open alcohol right now. but I don't know if that'll address her hold.
Yeah, exactly. I'm not.
Because I didn't put her on a hold. I don't have a hold on this file. It
Yes,
doesn't,
Eaton
they
County
know,
is
no one
Eaton
sent
County.
me, ma'am, I gotta have to ask you to stop talking. No one sent me anything that indicated that she was picked up on a, so. Okay, Miss Hunter, hang tight. We're gonna have to dig and find out what's going on. I'm gonna arraign you on your other one today instead of the 31st, and then see why you have a hold
Thank you.
for a probation violation, because, I mean, a bond violation, because I haven't issued anything yet. It doesn't help me. What is this? Oh, yeah, the file. And then can you also do a little investigation as to why she's got a hold? Thank you. Okay, are we ready on Mr. Baldwin?
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Reginald Baldwin, file number 22-02595, council appearance.
Brian Rangel, for the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Reginald Baldwin, who is appearing separately by Zoom.
Okay, Mr. Baldwin, today was the date that was set for a pre-trial. I have a count of malicious destruction of a building. How are we proceeding on this?
Your Honor, at this time, there is an offer from the state prosecutor, and here's the restitution.
Okay, I have a plea sheet. It says the people are offering for the defendant to plead guilty to an added count 2 of malicious destruction of a building less than 200 and to pay restitution and the amount of $1,506.02 to Motor Cars of Lansing. It says that there's a kilobrew of no upfront jail, and the reduced charge or amended charge is a 93-day misdemeanor, also punishable with a maximum penalty of $500 or 3 times the destruction or injury. Mr. Baldwin, do you understand that offer?
Yes, I do.
And you wish to accept it today?
Yes, I do.
Raise your right hand for me. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, I do.
Okay, you can put your hand down. Mr. Baldwin, you have the right in this matter to proceed to trial. You have the right to be represented by counsel at trial. You have the right to be presumed innocent until proven guilty. You have the right to remain silent at trial and not have sounds be used against you. You have the right to see, hear, or question any witness the prosecution intends to call. You have the right to call your own witnesses to trial or present evidence that you believe will further defense to this charge. And you have the right to have the prosecution prove each element of the charge that's being brought against you. They have to prove each element beyond a reasonable doubt. You would have to give up all of those rights today, sir, if you want to accept this offer. Do you understand that?
Yes, yes, ma'am.
You want to give up those rights?
Yes, ma'am.
Anybody threatening you to get you to waive your rights and plead guilty?
No,
Has there been any promises to you in exchange for you waiving your rights and pleading guilty?
no.
Are you currently on probation or parole?
Probation,
Is that with Berry County?
Berry County.
Okay, you understand that a guilty plea can result in the violation of your probation status?
Oh, shoot, no. I didn't know that.
Does this happen while he was on probation, allegedly?
No, I wasn't on probation when this happened.
Okay, okay, so it's not likely that this will result in a probation violation, okay? Do you understand that a guilty plea can result in a conviction that you would need to report to either your future employer or to your current employer?
For what?
For a guilty conviction.
Oh,
If you're gonna plead guilty to malicious destruction of a building, that's gonna result in a conviction, and you may have to report this conviction to your job or to a future job. You understand that?
I'm disabled and retired. I don't have a job.
Okay, well, what if one day you decide you want to get a job?
I can't get a job. Social Security office won't let me get a job.
Okay, so then you're not concerned, but you understand that this is a matter that you may need to report if you decide that you want to get a job, correct?
Yes.
Okay, and then you understand that a guilty plea could result in a conviction that may have impact on any immigration status you may be seeking, like if you wanted to move to Canada or something. You understand that that could impact immigration?
Yes, I understand that.
Okay, and that you're pleading guilty because you believe you're guilty, sir?
Well, at the time I was out of my mind and I had threw some rocks at that window. So yes, I'm pleading guilty.
Okay, well, it sounds like we have almost a factual basis. I'll let you continue with the questions.
Thank you, Your Honor. All right, Mr. Baldwin, on February 2nd of 2022, around midnight or after midnight, were you at Motor Cars of Lansing at 6505 South Pennsylvania Avenue in the city of Lansing, Ames County, Michigan?
Yes.
And while you were there, did you willfully and maliciously destroy part of the building there?
Not the building, just the window.
All right, but the window was in the building, was attached to the building.
Say that again.
You threw rocks at a window at Motor Cars of Lansing?
Yes, I did.
All right, and you did damage to the window?
Yes, I did.
All right, and do you dispute that the damage to the window was about $1,500?
I didn't think it was that much, but if it is, so nothing I can do about it right now.
All right, Your Honor, I have no further questions.
Okay, the court is satisfied. Is the prosecution satisfied?
Yes, Your Honor, thank you.
Okay, we're satisfied with the factual basis. We'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Okay. December 13th at what time? 8:30. It's not gonna be able to go that day. How long is he gonna be on probation in Berry County? How long are you on probation in Berry County?
I don't have any idea.
Okay, well, that's not good. They didn't tell you how long?
No, I'm still in the process of the case.
You can't be on probation if the case is still pending, sir.
Well, I'm on bond. I'm on bond.
Okay, that makes sense. So you're on bond, you're not on probation. Okay, that makes sense. Okay. Can we do the 20th? December? December 20th, at what time? 8:30? December 20th at 8:30 is going to be your sentencing date. You need to report to probation within 48 hours from today so that they can provide the court with, or prepare you to provide the court with the pre-sentence report and recommendation. You need to report to probation by, what is it, Tuesday, Thursday of this week at 11 a.m., okay, in person.
Where's the probation at?
They're here at the court, and we are located at 124 West Michigan Avenue. They're on the 5th floor, okay?
The what floor?
They're on the 5th floor of this
Oh,
building.
the 5th floor. Okay.
Do you have any questions at this time?
No.
Okay, well, then you're all set for today, sir.
All right.
What about Mr. Frazier?
Your Honor, was that the one where Mr. Samuels withdrew?
I'm not sure. I do know that.
I know that Mr. Frazier's case is a conflict case in my office. That's why
he needs a new attorney.
Yeah. I'll task.
Yeah, just the attorney conflict. Let me see. Yeah, it said he had conflict counsel before.
I'll let my office know.
Okay, Mr. Frazier, they're gonna have to get you new conflict counsel, so you don't have an attorney today, okay?
What about my hold?
What about it?
I'm gonna be able to bond out.
We're gonna get
PR.
Oh, yeah. Oh, you know, you missed 1, 2, 3, 4, 5, 6, 7 times.
It has something to do with my illness a little bit, and I got a support team now. I got 3 members.
I understand that. We need to get you, we can't be tracking you down anymore. This matter's been pending since August 2021. So we'll have the public defender get you new counsel because your other attorney withdrew because you would not remain in contact with them. So we'll find you a new attorney. You'll be remanded until then, okay?
So I gotta stay in jail till when?
And at least until we can get you an attorney and figure out how we're proceeding on this.
How do I get this off of here?
What about my attorney?
Yes.
Can you stay for a second? Can I discuss something with Mr. Berman really quick?
On which one?
Related to Mr. Frazier's matter.
Okay, I'm calling this jury in 8 minutes.
Okay.
I'll be because I waited for everybody to, well, I didn't tell you can leave. We get these people out of here. He's getting upset today.
Okay.
Because I've waited while you all talk to your clients, and then now we got the jury to come. I know they are. Okay, Miss Hunter, what happened with Miss Hunter? Did we find out?
Magistrate both said that there was bond violation on the file that's before you, but there was no packets.
How the hell I get this off of here?
File for arraignment.
Okay, someone give Mr. Frazier a new date. Okay, and then we're back on the record in the matter of the people of the state of Michigan versus Ramona Hunter. Ms. Hunter, I have a new file for you that was scheduled for arraignment. I'm going to handle it now. The people of the city of Lansing versus Ramona LaShawn Hunter, file number 22-02782. Are you putting your appearance on the record, counsel?
Thank you, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant Ramona Hunter, who is appearing from the Union County Jail.
Okay, and so the allegation here per citation is that on or about October 12, 2022 at 1:49 in the morning in the area of South Pennsylvania, Kalamazoo, and in the city of Lansing, Ingham County, state of Michigan, that you did allegedly commit the act of having open alcohol in public. That you either possessed, sold, or consumed open alcohol in a public park. Okay, and so that's a misdemeanor. The maximum penalty is 90 days and or $500 in fines. It says here that there was an open Bud Light beer in the roadway in the notes. And so you have the right in this matter to be represented by counsel. You have the right to proceed to a trial. You have the right to have a jury trial. You have the right to have the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. If you're found to be guilty, you are, again, facing up to 90 days in jail and or fines in the amount of $500. You understand that, ma'am?
Yes, I do understand. Yes, Your Honor.
Okay, and I will enter a not guilty plea on your behalf. Are you requesting court-appointed counsel?
Yes, please.
Okay, and the date of the allegation was October 12th. Which, let me see here.
Basically the same day she was arraigned on.
Yeah, I don't see how you could have had a violation because you hadn't been arraigned yet.
But again, she reports she was arrested on Friday at a convenience store where she admits to officers that she didn't use drugs, but she told officers she used drugs. So I'm
something different.
Yeah, she was arrested on Friday. She posted the bond on when you got her arraignment on the 12th.
I thought they were saying this new charge was the violation.
No, I don't.
So it's something else that I don't have before me. Okay, well, maybe they'll figure it out and get it to me so I can address it. As to the bond for the note, or the alcohol in public, I'm gonna issue bond the amount of 100 personal recognizance. While out on bond, need to report to all of your court dates, and not to use, purchase, or possess drugs, alcohol, or any other controlled substance.
Thank you, Your Honor. Did you say a $100 personal recognizance for the new one?
That's what I said.
Thank you.
No problem. Do you have any questions?
I wanted to know about the whole.
I don't know what the hold is on. I'm gonna let Miss Donnelly handle the matters that's before me now, then let her go dig up, find out what it is. If she can get it squared away, then I can have Judge Flores address it on my behalf. Okay? No problem. You're all set for now. For pre-trial. Oh, let me give you a pre-trial on the, it's before me.
November 7th.
November 7th at 10 a.m. will be your pre-trial on the open alcohol, okay?
Okay, what about the malicious destruction of a building?
Ms.
Oh, you
Hunter,
wanna
we're gonna figure that out.
Yeah, we gotta figure out why you have a hold on that. We're gonna reset that one, though. You did have an offer that will remain open. Give me a new date on that one.
Could you tell me what the offer is?
November 8th will be that date. At what time? At 10:30. Your attorney can get back in the private meeting room with you and explain the offer to you, okay?
Thank you. Have a good day.
No problem. Okay, and then we give Mr. Frazier a new date? Mr. Frazier, your next court date's November 8th. At what time? At 10:30, okay?
I'll have,
I'm sorry?
have a bond.
No, you're not getting a bond at this time. We'll see you on November 8th.
Besides, I think that's it for my morning. Besides, Mr. Barber, we had a problem with Mr. Barber yesterday from Clinton County. I guess they didn't bring him over again today. Okay, and then Travis Driggs was supposed to be in Clare County, but he got released, so I tried to contact him, so I don't. But Mr. Clark, he did try to contact me this morning. He had another court case in Macomb County, 845. He did contact me, so I would, if possible, can we adjourn that to next week?
Okay, they'll get your new date on that one. Let me go get my jury instructions in there and let the jury in.
Yeah.
No, they're gonna, so they adjourned everything.
And bring them over.
Oh, okay, Barbara, yeah, that's fine. No, you're not the attorney on that anymore. Okay, you have more than one case with him now.
She's here.
They looked it out one case because there's somebody involved in that case that we've already represented. So it's just the one. Okay,
I'll do it.
Did you set a date for Clark yet, Miss?
Sorry, I bugged her.
No, I haven't yet.
You said 1 week?
Yeah, next week should be fine. Okay, yeah.
Okay.
Hunter. Hunter again.
Yes. Hunter?
Or she leaving? She just left.
I don't even know who that is. Hold on, I'm still talking to them. One is a, $100 PR, and then the other one they're trying to figure out. Okay, thank you.
For Clark, you can do November first.
No, I put her in a break.
For your room, okay. Okay, thank you.
Thank you.
What'd you say?
For Clark, we can do November 1st at 1:30.
1:30, okay, thank you.
Yeah. Are they gonna be witnesses?
One is.
She is, so she's good to go outside.
Yeah. I have them all in the- I'll have to come up here. That's Miss Washburn. I've got her nollies right here. You can just wait in the hallway till she's done.
Yeah.
Mr. Morale, once you pick a jury, go ahead and come back.
Yeah.
Thank you. She is. So the race is good. Okay. It's dry anyways. Good point. That's the term.
You can be seated. Let me see here. You can close the door. I sent you the instructions for the trial. Did you forward it to me? Did you get them?
I do not. What bad.
I think I spelled your name like wrong, too. Let's see. It's Brian with a Y, correct?
It is. It's a charge of domestic assault, to your honor.
Yes.
Do you like us to refer the jurors by name or by seat number?
It's really up to her. What works better for her, because she usually asks what jury is, I think.
Seat number is fine.
Trend now for safety issues too, so
Go to old school and Simmons.
Yeah.
Thank you.
I'm sorry, you said what?
On. Where was it?
Oh, I see what you mean, under the witnesses' names. I mean, under my court staff's name. Domestic violence.
Yes. Thank you.
Did you get a copy of the jury instructions?
Sure.
You see anything else, Mr. Reed?
I did not, yeah.
Okay, let's see who's in my way.
Never received it.
Okay, I don't think that the ones before trial need any more things addressed, but we will do those, pick a jury, and then we'll recess and go over the procedural ones, I guess. Okay. Hi, what's your name?
Robin Frederick.
Okay, Ms. Frederick, you were scheduled to have an arraignment today for a probation violation, but I'm gonna reset it because I'm in the middle of a jury trial, okay?
Okay.
Give me the date, please. November 8th at 1:30, okay?
Okay. Okay. Thank you very much.
No problem, thank you. Okay, we ready to bring the jury in? Or do we have to address anything?
Yeah, I would just request the witness, Mr. Lester.
Okay, yeah, we're not bringing any witnesses just yet. We're just
Your
gonna-
Honor, we've already taken care of
Sequestrations of witness, yep, we're not gonna, I'll grant that order, but right now we're just gonna pick the jury. Do we need to address anything relative to the jury? Okay, sounds good, we can bring them in. Anybody get a worksheet? Probably not.
Thank you.
No problem. Yeah, I had- hold on. Okay, everyone, you can be seated. Okay, we're gonna put some people in the jury box. Juror seat number 1, Jessica Bateman. Number 2, Stephen Jacob Scott. Number 3, Trent Killinger. Number 4, Teresa Wilson. Number 5, Angela Penrose. Number 6, Charles Dion. And number 7, Now Yang. I'm gonna apologize in advance because every time I gotta do jury instructions, my Zoom becomes glitchy. But if everybody can turn their attention to this screen. Ladies and gentlemen, good morning still. I'm Judge Kristen Simmons, and it is my pleasure to welcome you to the 54A District Court in Lansing, Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition that is part of our heritage. The law says that both a person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused from this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do not understand it, if you do understand it, that is, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as jurors in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. Please rise and raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do, say so by saying I do.
I do.
Thank you. You can have a seat. I will introduce a few people to you. The first person I have is my right hand here, and this is Ms. Addie Nash. She is my court recorder. And then the person that brought you up, that's my court officer, Mr. Nicholas Bigelow. And this is a criminal case. It involves the charge of domestic violence, and I will explain that more fully later. The charge has been made against the defendant here, who is Mr. Christian Morel. Can you show your face so they can see who it is? You need to remove your mask. Okay. Thank you. The defendant's attorney is Mr. Mijas.
Good morning. My name is Harry Mijas, and my co-counsel is Nicole Smith.
Okay, thank you. The assistant prosecuting attorneys here are Mr. Randall Bierman and Brian Ray.
Good morning, I'm Brian Ray.
Mr. Mijas, can you list any witnesses you may be calling?
Yes, we will be calling Mr. Morel, and we will be calling Miss Morel, his mother.
Okay, what's Miss Morel's first name?
Sangria. Sangria Morel.
Sangria Morel. Does anybody know either of those parties? Okay, any prosecution witnesses, can you list them at this time?
Kayla Smith.
Anybody know a Kayla Smith? Does anybody know the lawyers here? Okay, very good. And we believe this trial will last one day. That's just for today. If you believe the length of time will be a real hardship for you, now is your opportunity to let me know. There goes the glitch. Anybody think that staying here today will be a real hardship for them? Ma'am, what's your name?
Jessica Anthony.
Okay, and you believe it will be a real hardship for you to be here today?
Yeah.
Why is that?
My daughter, she's 13. She's in a partial hospitalization program today and has been for a couple days now. Wanting to hurt herself.
I'm sorry, I couldn't hear you.
For wanting to hurt herself.
Okay.
And they may be calling off and on.
Okay, so you need to have access to your phone. Is that what you're saying? Okay, you have not made it into the hot box, so you might be safe. I'm going to hang on to you for now, okay? And then if you make it to the hot box, then remind me of that. I think that would be sufficient reason why you probably can't sit in a jury today, okay? Let me see if I can fix what's happening here. Anyone else believe that it would be a hardship for them to be here today? Okay. Last name again, ma'am?
Anthony.
I'm just gonna go ahead and release her now. You may be excused, ma'am. Okay. Try this again. Okay, some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes it you unable to sit for 2 to 3 hours at a time? Or does anyone have a sight or hearing problem? So can everyone hear me? Okay, you cannot?
I just want to have a question. How about knowledge? I hardly read and write, so did I?
Okay, do you understand what I'm saying?
Yeah.
Okay, because I don't think you have to read too much. I'm reading these to you.
That's why I'm watching you.
Okay, very good. But you can understand me clearly?
90%.
You're not sure?
99 maybe.
Okay, okay. So far, you've understood me?
Yes.
Okay, so if you don't understand, that was the other slide that we have, then you just raise your hand and say, let me know you're having a problem understanding, okay? And then we can address it at that time. Anybody else not able to hear me or understand? Okay, everyone see? And then we will not be sitting for more than an hour at a time. If we go an hour, I usually take a break when it's fair to do so. I don't like to break when people are in the middle of questioning a witness, but I need to make sure I can't sit for too long without stretching. So I make sure we all get that time. But does anybody have a problem with being here and sitting for the majority of the day? Maybe they have a hip bone issue or something like that. No? Very good. This is a criminal case, and the paper used to charge the defendant with a crime is called a complaint. The complaint in this case charges the defendant, Christian Morel, with domestic violence. And I'll read the complaint at this time. It says on or about August 8, 2022 at 1813 South Genesee Drive, City of Lansing, Ingham County, State of Michigan, that the defendant did, contrary to law, commit the act in count 1 of domestic violence, and that he did make an assault or assault and battery upon a Kayla Smith, an individual with whom he had a child in common, or an individual with whom he had a dating relationship, and and that this was done contrary to Michigan Compiled Law 750.812. The defendant has pled not guilty to the charge. You should clearly understand that the complaint that I just read to you is not evidence. A complaint is read in every criminal trial so that the defendant and jury can hear the charges. You must not think it is evidence of his guilt or that he must be guilty because he was charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful, considered examination of the facts and circumstances of this case. Okay, that concludes our slideshow, and we will let Claudia begin with you, Mr. Ring, or is it Mr. Beerman that's going to handle it? Okay, you can proceed.
Can everyone hear me okay? If I need to speak louder.
You can remove your mask while you're talking.
Thank you, Judge. This is much better. Has anyone here ever served on a jury before? Juror number 6. Was that in a criminal matter or a civil matter? Sorry, criminal. How long ago was that? 30 years. Long time. What the matter was about?
Yeah, it was about
Okay, an assault. And were you guys able to reach a verdict on that? Yeah. And how was that jury experience for you? Was it overall a good thing, overall a bad thing?
It was a good thing.
This case is going to be based on a little bit of credibility. You, the jury, are going to have to determine the credibility of the witnesses. Anybody here have kids? How many kids do you have? How do you determine the credibility of the kids when they're both telling you the same thing, or different things?
Usually based on their history. I mean, one kid so.
Do they have any visible tells that you look for?
Yeah, I think that's all.
And what are some of those visible tells that you look for?
My son bites his lip.
Okay. So, and who else? Sorry, who else had kids? You're number 2. You don't have kids. How do you determine the credibility of someone that you meet every day?
Well, considering my job as an investigator for Department of Health and Human Services, what I do is I take everything that they say and I look at their past history, if they have any. I talk to other people that have knowledge on them, and based on the totality of them, what I found, that's how I kind of figure out what they're doing.
Number 3, I see the nod in your head. You had 2 people telling you the same story. You've never met them before. All you have are 2 people telling you, or sorry, different stories. Yep. All you had was 2 people telling you different stories. How would you determine which one's credible and which one's not?
I think put the evidence. And it's not that.
And what kind of evidence would you be looking for?
I guess I wouldn't really know until I saw the evidence.
I think medical reports are important. How many people here would like to see a medical report in the case of an assault? 1. And if you didn't see any medical reports, would that would that hinder, would that count against, the credibility of somebody? If it would count against the credit, we think it would count against the credibility of somebody if there were no medical reports. Rick, please raise your hand. That's good. Thank you for your honesty. You're number 6, thank you. So how many people here believe that there must be an injury, some sort of injury for an assault to have taken place? That's to clarify. Are you implying that's a physical assault? Just a physical assault. We'll go with physical assault. You think there needs to be some sort of injury for physical assault?
There can be internal damages to the body that are just a physical.
Okay, we'll get on 3. So has anybody here ever been the victim of an assault? Does anybody have any friends who are victims of assault? Family members, friends? You're number 4, you're nodding your head.
I was gonna say, if you hadn't asked, I was gonna volunteer. My mom was, I grew up at home with a lot of BB against my mom. Medical.
So domestic violence against your mom.
I'm gonna ask everyone to speak up because you're wearing a mask and she has to be able to hear everything that's being stated, okay?
Well, and I apologize for my voice.
Oh, you're completely fine.
You
need me to repeat?
Did you need to repeat?
I'm sorry.
Did you get what did you get her?
Could you say it one more time?
Yeah, you can repeat.
I just grew up in a home where there was DV all the time with multiple men against my mom.
And DV meaning domestic violence?
Yes.
Okay.
And did your mom ever report any of that?
Nope.
And was there anybody else that had been family, friends, victim of assault? Yes, sir.
Yeah, my best friend was, he had a 19-year old.
Sorry to hear that.
She got away.
Did she talk to you about that?
She did.
Anyone, did you have to make any kind of statements for the police or anything?
No, she got him.
Can you keep your voice up, Tom?
I'm sorry.
Can you speak up?
Oh, sorry. Yeah, she had him incarcerated on her own.
Has anybody here ever had a personal experience with police? I'm counting like speeding tickets as well. I know we might have all had some of those.
Had a speeding ticket.
Sure, number 5. Yeah, you had a speeding ticket. How did that interaction with police go?
Oh, it was slow. It was no problem. I handed them my license, no issue. Got my ticket and went about my day.
Has anybody else had any other interaction more than a speeding ticket with police?
I mean, for my job, I work alongside law enforcement on numerous occasions.
Okay. And do you think that? Never. Sorry about that. So nobody else has had any experience with police? Can we take down reports or anything? Giving a report to a police officer? How did that interaction go? It was fine. Did anybody have a negative interaction with law enforcement during a speeding ticket or anything? Jury number 7, I'm going to come back to you with your friend. Do you feel that your friend was treated fairly during the process? The process of going through the court system?
Yeah.
Do you know if there was a trial?
There was not a trial, only because he had tickets added on to his.
Okay. So, does anybody watch any crime shows on TV? Any courtroom shows? Any crime dramas? Listen to any crime podcasts? If you do, please raise your hand. Juror number 4. What do you watch or listen to?
CSI, just because my is into all this stuff. So.
CSI.
CSI and CIS.
And today is not going to be anything. Do you expect today to be to be like that?
No, she's 22, so there's like 27 years between us, so yeah, that's her world.
So does anybody have any friends that work in the police field? Family members?
I have a hockey friend and friend back home.
Do you talk to them regularly?
Hockey friends, some regularly, older friends, not so much.
They tell you kind of about their job and what kind of cases they're handling?
They have not.
Okay. Does anybody else have any friends in law enforcement? Yeah.
We never talked about his job.
So one of the things is I have to prove the elements of this case beyond a reasonable doubt. Beyond a reasonable doubt. There are two elements in this case. Those are the two elements that I must prove to you that happen beyond a reasonable doubt. I must prove to you that they had one child in common, they had a child in common, or they were in a dating relationship. And I have to prove to you that an assault occurred. Does anybody have a problem with me only having to prove those two elements? There might be other things that you might want to know, such as what color of shirt somebody had on that day. And those aren't, does everybody understand that I don't have to prove everything that happened that day, just those two elements? So in this case, I had only named one witness to you, and that is the victim. And the victim will give her testimony. And if you feel that you believe the victim's testimony over everything you've heard, is everybody comfortable with coming back with a guilty verdict by just hearing the victim's testimony and nothing else? If you think you'll have a problem judging this case based on just the victim's testimony, can you please raise your hand?
I'm not sure. The fair response.
That's fair. Thank you, juror number 3. I saw it. Juror. And juror number 7.
I'll have to hear both sides.
Yeah, then that's kind of where I was at. If you hear both sides, but you believe my victim, and we don't have anybody else besides the victim telling you her story, but you believe her, is everybody comfortable with the conviction beyond a reasonable doubt?
Can I ask a question?
Yeah.
Just to clarify, so it means, if she gets up there, tells her story, but you don't have a medical report showing this and that, whatever, am I okay to believe her saying so and so assaulted?
Correct. If she's up there and she's telling you her story and there's no medical report, you're not going to see a police report in the matter. There's no pictures. Are you comfortable? If you believe her, convicting beyond a reasonable doubt. Juror number 4. What's beyond a reasonable doubt to you?
Without question.
Is it without question?
Yeah, without question. You know, well, what is that? Without having any reason, without.
Okay. I have no further questions, John.
Oh, that's.
Good morning. It's a late one. I'm sorry that took so long. My name is Harry Mayhouse again. I know these things go really quick. Wanted to introduce myself to you. Juror 6, have you ever heard the term flip of a coin?
Yeah.
What's it mean?
Means chance.
Could go either way. Now, we talked about kids. 2 kids say one thing, the other says the other. Proverbial flip of a coin. Parents, you got to get it right. You got to figure out who did that. Okay? What if you can't? What do you do?
I don't know what I would do. I would have to trust my instinct, my gut, and hopefully think how they're my children and I know them for the most part.
One
I'll be able to
option.
figure it out.
One option is they both go to timeout, right?
That's true. Yes.
Are you comfortable with the fact we don't have that option? Right? Very, very.
Scary to a certain extent.
Yeah. when we talk about reasonable doubt, not just one person, correct? It's the totality of circumstances. Would you want to hear from the defendant?
Yes.
You understand he doesn't have to testify. You wouldn't hold that against him. But it's likely he will testify. What if you find him somewhat believable? The witness says she was assaulted. Much believable. Is there reasonable doubt?
That's where you would follow those gut instincts.
Say that again.
I said that's where you would follow those gut instincts. And also, I'm a social worker, so I would pay attention to their body language. That's what they're saying.
So if I told you reasonable doubt, would be if there is a reasonable doubt to guilt, even if you feel like maybe you did it, is that still reasonable doubt? Because the standard here is beyond the reasonable. And something you said earlier was that it has to be absolute. Could you repeat what you said before?
Oh, yeah, I mean, I think it's an abstract concept, because it's beyond reasonable doubt. It's different for every person. It'll become a different set of values. That's what I think.
Because the absence of evidence, such as a medical report, create reasonable doubt. For one.
Well, you could, to me, be assaulted and not have a reason to go to the doctor. Like someone can hit you and that's an assault, and you will need to see a doctor. So I don't think we need medical support. And then they still hit you.
And then again, see, we said one thing, we said what?
Yeah.
So essentially, what we're talking about is a he said, she said. And we need to figure out not necessarily who did it, but has the government proven it was beyond a reasonable doubt? And in the law, that's the highest thing. That's why if I have any doubts, it's not guilty. You don't go back to the kids and say, I can figure this out because I got to make sure we did it. If we give innocent now, he's innocent now, he's innocent all the way up to the point of beyond a reasonable doubt, and if there's a reasonable veracity of the statements. The fact that it lacks any other works. Are you comfortable here, Chief, with coming back with the not guilty?
If I receive the evidence that points in the direction that it's not guilty, then yes.
You feel your background biases? You said you work for DHS.
I don't feel it biases because I go into everything with a blank slate. All I'm told is what's being said at the time, and then I have to look at all sides and what they present me at that time.
Everyone here, please think about this, because you may be up. If it's here in court, does that make you lean towards guilt?
No.
No?
No.
No.
Because there's a police report. The police reported it. Does that mean there's any indication of guilt?
So they're saying what they were told.
So the answer is no. Is that a fair to say collectively? Or do you have any doubt? No. What's that? Thank you for coming. Sorry if I put you on the spot, but I appreciate your answers. You were very kind and you were great. Thank you.
Challenges for cause.
None for cause, Your Honor, thank you.
You may. Give me just a moment. Okay, we're gonna thank and excuse juror number 4. Thank you. You may be excused. Jacob Poirier, did I say that right?
Yes.
Thank you. Okay, Mr. Flores, no, let's see here. And you can continue with your argument because there was 2 new. Correct, or was it just one? We only replaced.
There was only one. yeah.
Okay, but you can continue.
Juror number 4, have you ever had any interaction with law enforcement?
Yes, I have.
Can you tell me what that was? Sorry. Speeding tickets?
Yes.
Was that was that a positive interaction with law enforcement or was that a negative interaction with law enforcement? Do you feel like you were treated fairly?
Yes, I did. I even had a discussion this morning with the police about my vehicle.
And were you ever the victim of assault or know anybody, family, friends that were a victim of assault? No. What does beyond a reasonable doubt mean to you? Sorry, I can't hear you.
All evidence are pointing at it.
And you had to judge the credibility of 2 people telling you different stories, and that's all you had were 2 people telling you 2 different stories. How do you do that?
At that time, I would have depends on what question and also that with the evidence.
Can you speak up?
The person telling me.
Thank you. No further question.
Can you repeat your answer? Just take your mask off if you don't mind, but speak a little louder. I think the judge, my associate, my co-counsel didn't hear it.
About the question that he asked?
Yes.
Okay. He asked about if 2 people telling me how do you do school? At that time, then so
Repeat that. I don't mean to, maybe I'm missing something. Repeat that last part.
the evidence is like who's right, who's giving the right.
So you'll weigh the evidence between the one and the other.
Yes.
And which one seems more credible?
The person who I think that
When the judge instructs you on beyond a reasonable doubt, will you be able to understand the instruction and promise to follow it?
yes, I will.
Even if reasonable doubt means that although the witness who says she was assaulted seems credible, if the other one also seems credible, that would be reasonable doubt, and you would have to find that guilt.
Evidence.
I don't get into personal issues too much, but I saw that your wife or your spouse is a dispatcher. What is your spouse a dispatcher? Like, is she with the police or?
No, I tried trucks.
You drive a truck, oh, okay. So it's a private trucking thing. Thank
Any challenges for class?
Nothing to people, Your Honor. Thank you.
Nothing, Your Honor.
Any pre-emptory?
Nothing to people, Your Honor. People are satisfied.
Your Honor, people are satisfied.
We get it.
The
The defense is
defense is
satisfied. Okay. Ladies and gentlemen, we have a jury and you are the lucky 7 for today. Those that are of you that are remaining in the gallery, we thank you for appearing today. We were almost down to the wire, as you can see today. So you see the importance of appearing so that we can have a diverse set of people to select from. But your services will not be needed for us today, but we thank you again. And then you can follow Mrs. Mailing, she'll get you to where you need to be. The rest of you will be serving today as our jurors. We are going to take a brief recess so I can do some housekeeping matters. I'm going to have you taken into the jury room during that brief recess time. And then we'll come back and I'll give you some more instructions, okay? Okay, all right. Hi, sir, what's your name? Oh, he's not, he just started audio. I'm assuming he was the other PV arraignment. You have your sign. And then in terms, did everyone get the jury instructions?
Yes.
Okay. Do you see anything I need to change? Okay, what's your name, sir?
Justin Robert Huffman.
Okay, Mr. Hoffman, we're in the middle of a jury trial, so I'm gonna reset your arraignment for your probation violation, okay?
Okay.
It's gonna be November 8th at 1:30.
November 8th at 1:30. Okay. Okay.
All right, thank you, sir.
Thank you, Your Honor.
No problem. Thank you, and you may be seated. If you want to turn your attention back to the screen, we have some procedural instructions here. Ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Please rise, jury. Do each of you do solemnly swear or affirm that in the action now before you, before the court, you will justly decide the question submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court? Please say, I do.
I do.
Thank you. You can be seated. You will have a written copy of the instructions I am going to read to you, and they'll be provided to you at the end of the proofs when you are going into the jury room to deliberate. You may refer to them at that time. Since no one can predict the course of the trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a written copy of my final instructions for you to use during deliberation. Now I will explain some legal principles that you will need to know and the procedure we will follow in this trial. The defendant is charged with a crime of domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. Did I skip one? I did not. Okay. I thought we were- The defendant is charged with a crime of domestic violence. To prove this charge, the prosecutor must prove each of the following. Try this again. Oh. The defendant is charged with the crime of domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted and battered Kayla Smith. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit the battery or to make Kayla Smith reasonably fear an immediate battery. At the time of the assault, the defendant must have had the ability to commit the battery, or must have appeared to have the ability, or must have thought he had the ability. A battery is a forceful, violent, or offensive touching of a person or something closely connected to him or her. The touching must have been intended by the defendant, that is not accidental, and it must have been against Kayla Smith's will. Second, that at the time, Kayla Smith had a child in common with the defendant, Christian Morrell, and was a person with whom Christian Morrell had or previously had a dating relationship. A dating relationship means frequent, intimate association, primarily categorized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about August 8, 2022 within the city of Lansing, Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements, which we just read. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. The trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may or she may make an opening statement after the prosecutor makes theirs, or they may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify that may show you exhibits like documents or objects. The defendant's lawyers has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyers will make their closing arguments, like opening statements. These are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony, and then what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin or ethnicity, gender identity or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case. When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true because one of the lawyers asks questions that assume or suggest that it is. I may ask some questions of I may ask the witnesses some questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to Mr. Bigelow, my court officer, who will give it to me, and do not show your question to the other jurors. Everyone has a pen and paper? Okay, great. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rules or ruling for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to those interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it is nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop, explain that you are a juror and you are not allowed to discuss the case. If they continue, leave. Report the incident to the court staff as soon as you return to the court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So, to be fair to both sides, you must follow this instruction. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about this case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you must not post any information about the case on social media websites or in any other manner. If you discover that jurors have violated my instructions, please report it to my staff. You may take notes during the trial if you wish, but of course you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see that we have chosen a jury of 7. After you have heard all the evidence and my instructions, we will draw lots, that means pick names, to decide which one of you will be dismissed to form a jury of 6. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in this case until you go to the jury room to decide the case. You must not let bias, prejudice, or a public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of the other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. Okay, it is 12:40. That concludes the procedural jury instructions. I am going to give you all a 30-minute break for lunch. And we will be back here at 1:10. Remember my instructions that you're not to speak to anyone because they may be connected to this case. If you believe that someone is violating those rules, you'll want to report that immediately upon returning you don't know anything about the case at this point, so it's difficult for you to discuss what you've heard because you haven't heard anything, which is why this is the most appropriate time to take lunch. And there are a couple of places open downtown, and then you want to be back here no later than 1:10 so that we can get started with opening statements, okay? All right. You can be excused.